It was right before Instant Messenger.
All right.
It was like I was really undergrad.
Yeah.
Everybody was like,
Let me
this is the coolest thing
make
I've
our
ever
co-host
seen.
share.
Because it was before texting. Texting wasn't even really a thing yet.
Gonna
We had to
start
be
just,
under-
Focusing on random people.
Yeah.
Very
Wow.
Okay, we should be good. So Kendra, your co-host, so you can share whenever you need
Okay,
to.
great. Can people on Zoom hear us?
Yes.
Okay,
Yeah, looks
great.
good. All right.
So yeah, okay, we can get started. So before we get started, I did want to discuss a couple of things. So about Article 10, when can we expect that to be put up for?
Yeah, I'm working on that. We're working on that every day. As soon as I have an update, I'm gonna give it to you. Unfortunately, I just don't have one for you in terms of a hard date.
So like, are you like not in contact with the Board of Trustees, or, I mean, how does that?
No, I'm not
how does that-
directly in contact with the Board of Trustees, but through upper administration, that's how I get in touch with them. So like I said, as soon as I have an update for you, I'm gonna give it to you. I just don't have one right now.
Well, I mean, you understand that, like, next time that you say that the university has no interest in doing back pay, we're gonna have a hard time
I
taking
understand.
you seriously.
I understand.
So yeah, we do hope to hear about that very soon.
As soon as I have information, you will be the first person I call.
So then the other thing that I wanted to say was the CBA document that you sent us. I think it needs some reformatting because
Okay,
just because like when we try to make edits, like me and Hannah have spent a lot of time just working on formatting. And so it would be great if we could, and especially there's a few things which like going to a sub bullet point, like
Yeah.
it messes up the indentation and
I don't
everything.
disagree.
Yeah.
Like, if we want to do a clean type, I don't even mind doing a clean type. If we can just get through the language, and then I don't even mind taking the time to literally start a new Word doc and type it. It was one that it was an old one. It had been updated to the newest file format. You know, that's always kind of wonky.
Yeah, yeah.
And then it got
That's
updated
yeah,
again.
it's definitely.
And
yeah.
some of it's justified, some of it has weird like word spaces.
Yeah,
It's
yeah.
really, really kind of
Yeah.
messed up. So I think that's perfectly fine.
Okay.
Yeah, I'm with you. And I don't even mind taking the time to do that.
Uh-huh.
I just wanted to, like I said, I wanted to get it paginated for the purposes of us getting through bargaining.
Yeah.
If you want to do a clean type after, I don't mind.
Okay.
Just keep in mind that we're gonna have to both make sure that if you literally do a clean type, you just gotta make sure that we don't inadvertently make an inadvertent change or have a Scrivener error or something like that.
Sure, yeah, I understand. Okay, thank you. So the first article that we will present is our counter proposal for Article 8.
Okay,
Just hand this over to you guys. And then we put it on Zoom. The wrong one. There may be some extra copies.
Yeah, there are.
So for those of you joining on Zoom, Article 8 deals with leaves of absence. Our main point here is that, so last time UF's team presented a proposal which sought to address essentially unpaid leave. Currently, we have 8 weeks of paid leave, but the getting an extension of unpaid leave was not very well specified in the language of the contract. So our main changes to the proposal that you sent us last time was basically that we have stricken out 8.3F, which says that a GA must be in at least the second semester of employment as a GA to be eligible for paid leave. And so, we thought that, if someone gets, seriously ill in their first semester, like they shouldn't be denied the paid leave just because it's their first semester. And similarly for unpaid leave, we have changed, it's mostly the same as your proposal, except for 8.3 or 8.4D, Basically, we've changed it so that an employee can be eligible for up to 12 weeks. In any 12-month period, and but each request of unpaid leave can only be 6 weeks at a time. And that's also reflected in 8.4B, which says that each unpaid leave must be continuous and may not exceed.
Can you go through that again?
Sure,
I didn't
yeah.
quite follow it.
So basically, the way you had it last time was that you would get 6 weeks of up to 6 weeks of unpaid leave at the
Right.
discretion of the university, and that you could not get another request for unpaid leave after another year.
So would you want it to be on like a rolling calendar, more like traditional FM? Like, it sounds like you're asking for like a rolling calendar that it would move as
Well-
the time progressed.
Right, I mean, in the sense that it would be kind of, we're just trying to make the language similar to what is in 8.3A, for example. Which says that, you know, you get 8 weeks of paid leave during any 12-month period. So it was just to make that the same, but also, you know, potentially if someone needs a little more than 6 weeks, that they can request like another section, but you know, at each request can only be for a 6 weeks period of unpaid leave.
Okay,
And a total of 12 weeks in a 12-month period.
and it would not run concurrently, but it would be subsequent to the available paid leave.
Correct.
So I just want to make sure I understand. So under your proposal, it would be possible for somebody to have 20 weeks of leave in any 12-month period.
It would be possible, but of course, the 12 weeks is at the discretion of the university.
No, I get that, but
Yeah,
I just want to
yeah,
say,
it'll
like,
be a
if
total-
we go to like the,
The
Theoretically-
absolute extreme, yes. absolutely.
Theoretically, it would be that you can do the 8 weeks and then 6 weeks, and then that's only one continuous, and
Right.
then you can get another 6 weeks right
Gotcha.
after that, yeah.
okay. Robert, do you have any questions about that? Because it's probably more in the HR world than anything else in terms of clarification or questions.
The strikeout of F on 8.3,
Mhm.
I'm sorry, I don't have a current language. Is that this now?
That exists now.
Oh, yeah,
That
that wasn't something that that wasn't a change.
That was not a
request.
proposal
Okay,
you
so
made,
this
no.
that's current contract language.
That's
You're
current
requesting to strike.
Yes, that's right.
Okay.
I feel like you kind of, you understand kind of what they're asking for.
Yeah.
Okay.
So if you were asking for a second set of 6 weeks, would you have to have 10 days in between? Or I guess,
By the letter of the contract, yeah, since it would be a minimum of 10 days.
or maybe if
request.
it was like 10 days before your unpaid leave ended, you could request another 6 weeks.
Yeah,
Right.
I just wanted to.
I mean, that is the
Fact that
language
it's-
that we didn't change anything in that
Right.
part. That was the one that you
yeah.
said.
But this is adding the second,
Right.
like you have
Right.
another period. I just
Right.
wanted to
It would,
administratively if we're. make
Yeah,
sure
no,
it's
I
fair to
understand.
people who
Right.
be administering it.
it can be consecutive, but the second 6 weeks would still need to be approved again.
Okay.
Yeah.
And I apologize for my ignorance here. So this relates to your employment, right? So you're requesting an unpaid leave. What's happening academically during that time? Are you also on a leave?
So I would assume just like with the paid leave, it's, you know, the academic stuff would be handled through the graduate school.
Yeah.
And, you know, the CBA doesn't necessarily, say anything about
Yeah.
academic stuff.
Yeah,
I'm
and
just more out of curiosity.
it entirely depends on like why you're really taking the leave, because for example, if it's medical, you can go through a medical like withdrawal or a medical leave for the semester, things like that. So really, it's pretty much separate, like this depends on why you're taking the leave.
Yeah, I don't think we're ready to necessarily give you we'll respond to this. I think one of the concerns I have, that we're likely to sort of, and like I said, I'm not ready to articulate the exact component, is possibly some consideration with respect to the beginning of semesters. Because if you have somebody who goes out on a 12-week leave and it winds up lasting 3 weeks into a new semester, that person who may have been on a teaching assignment is pretty much precluded from doing a teaching assignment. So there's,
Yeah.
there's probably some guardrails we may want to consider or talk about with respect to if you're primarily assigned to teach. It's a little bit easier if you have a research assignment because you can kind of work it out with your advisor. But if you're scheduled to teach a section, the deeper you go into a new semester, the less likely it is or much more work it takes for the unit to figure out who's going to step in your absence. You can't delay the start. So anyway, that's something that we're probably going to want to analyze and think about.
I think we're open to a proposal that
Yeah.
deals with that.
I mean, there is some language in there that already requires like a minimum amount of time,
Right.
you know, before the request. So
Right.
if that needs to be, like, maybe you thinking like extending that to give more time, or
So
maybe just something different for TAs?
I'm thinking that unfortunately, all terms are not created equal, right?
Yeah.
So people needing to take time, and we've had a lot of conversation about this, somebody needing time off in the summer is just different than somebody needing time off during the year.
Right.
You know, because the teaching loads are different, you know, and again, I'm thinking this unfortunately is probably more focused on the TA portion than on the
Right.
RA portion. It's just the teaching loads are different. And, you know, especially in some of the units, there is a very high proportion of our assigned GAs that have teaching assignments.
Mhm.
And some of those have, you know, they have to run. And if they
Right.
don't, pulling in an adjunct last minute or something like that can be difficult. So again, we just want to probably think about if there's a way that we can sort of retain what you're asking for, which
Yeah.
is really additional consideration. We just want to go back and take a look at, okay, what would that mean in terms of if we look at this case or if we look at that case? So thank you for this.
Sure.
Any other questions from us on this article? You guys have another one that you feel good?
We have several.
Okay, great.
Yeah, and I just want to clarify for anyone joining on Zoom, like, what we're discussing here is just about an extension, an unpaid extension to the paid leave, which is already part of the contract. And if you weren't aware of that, you can't, you know, there are several qualifying events for which you can, for which you're entitled up to 8 weeks of paid leave. And what we're currently discussing is just an unpaid extension to that leave, should that be necessary.
Well, we actually wrote this again, so it doesn't have to only be an extension. You could just request an unpaid leave. It doesn't
Oh,
have to be an
okay.
extension. of
Yeah.
medical. That what our intention wasn't to make it, because sometimes we've had a lot of requests and we had a lot of conversation in HR and with the grad school within talking about, there are times when it's not medical and it wouldn't meet those requirements, but our employees sometimes still need to leave and are willing to take it unpaid. So I'm not trying to, the intention is not that it's only if you already qualify for paid leave, this would be an extension. It's a standalone type of leave.
I
It could be
see.
subsequent, but it's not required that you do the one before the other.
Okay, oh, I actually did not realize that.
Yeah.
Okay, thank you for clarifying that.
That's why the 12 weeks really helps too.
Okay. So, the second, proposal that we are bringing today, just give me a second. So we are also responding to your, use deduction proposal.
So thank you.
So again, just for some context, for people on Zoom, a law went into effect over the summer, which basically made payroll deductions from of union dues illegal for public sector employers. And that law is currently being contested in the courts. And so because that law has affected an article in our contract, Article 17, we've entered negotiations to address that. So just in some of you who may be on the call, you know, if you were members previously and if you haven't signed up for the new dues collection system, you're actually not currently a member. So just check about that if you're not sure. So for Article 17, as we've stated repeatedly previously, our goal is to preserve the current language and ensure that it becomes enforceable should the law be struck down in the courts or changed in any way. And so Article 17.1 deals with this, and this is exactly the same proposal as last time. As we said last time as well, that this is the proposal that has been agreed upon by FSU and FSU GAU, and it was actually the proposal that was brought forth by FSU. And their their article relating to union deductions and severability are pretty much exactly the same as ours. So I think, I think you should also ask your counterparts at FSU why they found this to be an acceptable compromise and why you don't. Secondly, we also discussed last time, Judge Walker's judgment that the public employers are obligated to bargain to set up a alternative dues collection method. And so for that, we have both Articles 17.6 and 17.7. So 17.6 basically asks the university to to essentially direct employees in the unit to the alternative dues collection system that has been set up by our parent unions, which is called eDues. And basically, the university has to deviate from the current contract language about dues because of this new law. And we feel that it's important that you inform your employees about this. And that's why we also cite Article 19.8, which is says that the university agrees to work with GAU to disseminate information. And because this is information that directly affects employees' contracts, we feel that you should provide that information and also provide a link for signing up to eDues. And through the following methods that we've listed, one is a letter in the mail, another is an email sent to all employees, and that this should also be mentioned in all future letters of appointment. And we will also put that in our proposal for Article 4 as well.
Is 17.6 contained within what FSU agreed to?
No, that is not.
Okay.
No. That is, again, as I said, something that came to us after we read
Okay.
Judge Walker's decision. 17.7 essentially says that if we agree to bargain over an alternative dues collection system set up through the university that's not payroll deductions if the highest court that has jurisdiction over the university upholds law and the rest of Article 17 continues to be rendered invalid. And so from our perspective, this proposal covers all possible scenarios. So one is the current scenario where most of Article 17 is invalid and unenforceable, but the law is being litigated in the courts. And so for the time being, we would like the university to appoint the members of our bargaining unit to eDues. There is another scenario where the law is struck down or struck down in the courts or changed by law, in which case we would want Articles 17.2 to 17 through 17.4 to be immediately enforceable. And lastly, there is the situation where the law has been litigated and has been upheld by the highest court that has jurisdiction over the university. In which case we will agree to bargain with the universities to set up an alternative dues collection system through the university itself. That is, of course, an alternative to payroll deduction. So yeah, that's our proposal.
All right, I've got some comments. I'm gonna probably take it in reverse order if you don't mind. So
No
with
worries.
respect to 17.7,
Mhm.
so here's what, it's not a complete difference, but it's a slightly different perspective on how to handle 17.7. We're currently in full book bargaining. So if there is some concern that you believe that the ongoing litigation may wind up changing or upholding the law, rather than having a provision in 17.7 that we're gonna re-bargain it, especially because you keep the other language in here. What I would recommend we consider doing, at least with respect to this provision, is to, as we've done before, actually just add a provision in the article of sometimes we put it in 26 and sometimes in Article 25, where we talk about pre-agreeing to reopen particular articles during reopeners.
Mhm.
Because I would hate to hold up this full book based on waiting for this to be finalized, because I don't know if that's, do you have any line of sight, Lydia, on how quick that's gonna be, Olivia?
I think it'll be a while.
So what I'm saying is that
Yeah.
I think we can probably get to the same effect of saying, look, we will agree to reopen that article as part of next year's reopener.
Mhm.
And then irrespective of what the courts do or don't do, we will already agree, look, we're gonna reopen 17 as part of next year's reopener. We don't need a provision in 17 itself. Because I don't want to I also don't want to pre-agree necessarily, depending on what the courts decide, because I don't think any of us have a line of sight right now in terms of what's gonna happen.
No, yeah.
But I think we would be amenable to considering reopening 17. I don't think that, I mean, I don't think we have any objection to that, which I think is kind of what you're trying to accomplish.
Mhm.
I mean, I don't know if that's something that you would consider.
Um,
It sort of addresses that want, which is to say, look, we want another bite at the apple, basically. We want to be able to talk about this again, which I think we all understand.
I think our biggest concern for this article is that if the law ends up getting like struck down completely, we just don't wanna have to like re-bargain for what's already in there for the
I get that.
deductions and stuff.
I get
That's really the main concern, or that's why we're trying to just keep the language in there and then just say it's not valid until it is.
Yeah, I got it. Yeah, so I think that's probably one of the things that you'll see. It may be a combination of the other article
Yeah.
as opposed to agreeing necessarily to this particular thing. I have more trouble with 17.6,
Mhm.
and the reason I have trouble with 17.6 is because the time and money that the university would have to spend preparing that documentation, mailing that documentation, I think that most courts would probably interpret that as helping you with organizing behavior, and I believe that's a direct violation of the unfair labor practice statute. I would defer probably to an attorney on that. I think that one of the ways that other units are handling this is they are asking and getting their annual roster, that has all that information, so that you have updated contact information for everybody in the bargaining unit, which you're entitled to. And then you all are free to do with that as you will. But to put the university on the hook for preparing and taking on the postage cost and mailing and providing a link, I think most independent courts are going to interpret that as we are literally helping you organize, which we are specifically prohibited from doing.
Well, so I mean, I think, if you want to add a provision, something in that letter or email, I mean, maybe if the letter is too costly, at the very least, in the future letters of appointments and an email would at least inform employees about how the law has changed, how the contract is being enforced. And also, as it contain, as far as unfair labor practices are concerned, I mean, you can also inform the employees of their constitutional rights, right? They don't have to join a union if they don't want to. They can't be discriminated based on their membership status.
Right.
So it's not like you're not asking them to join the union. You're just telling them the current method that and many people who were previously members don't realize that they're not members anymore. And that was done through the university previously, right? And so you're just informing them that that is no longer happening, and that if you want to continue being a member, this is the method to continue being a member.
So the way that I'm reading the purpose of 17.6 and 17.6A is that the university is responsible for sending a letter with the express purpose of explaining them how to give dues to the union. Like that is how I'm reading 17.6. That's the purpose of that provision, is that we are preparing and mailing on your behalf a letter to them saying this is how you rejoin.
Yes, I mean, that is a alternate, we are trying to set up an alternative method for collecting dues, and
Right.
as the judge had noted, like public sector employers should bargain with their employees to set up an alternative.
Yeah, I don't think there's any, I don't think we're arguing that.
Mhm,
Do you have any thoughts on that, Olivia?
I mean, I'm not off the top of my head, but
Okay.
I'd rather think about it.
All right,
I
yeah,
Yeah, because I think it's just really, people are just not aware, especially, not only for just people that are already a GA, but also people coming in as well. So especially if they already, like if they've been a part union before that's done payroll deductions, they just may not be aware of the law, and that it's completely different for this. So
right,
that's kind of just, where we're coming from. We just want to make sure they're informed.
Yeah.
I would say at a minimum, at least a part of the letter of appointment, having that information.
mhm,
Maybe the mailing is too much, like you said. But
yeah,
yeah, I think that's probably more likely that we would be able to agree to some sort of something in there that points that out. Because the additional cost would be negligible, if any.
Right.
But this seems like the whole purpose of doing this would be for,
so if the letter thing is what's holding you up, I mean, I think we're okay with not having that, but at least in future letters of appointment and an email, I would think is basically a no cost kind of thing.
I think we'll talk about that.
Yeah,
What's stopping you all from emailing directly since you have that information?
We do email people, but you know, it's different when someone receives an email from the university itself, like from their employer, informing them about changes to their contract, or how law has affected how that contract is going.
So we did actually notify all of them when it happened, as we emailed you that we were going to. So we did already send that email notifying them of the stoppage of their payroll deduction. So I don't want you to think that that didn't occur, because it did.
Mm.
I mean, it happened back over the summer. We told everybody. So that part's already occurred.
Well, it's also new people joining where we may not have their information, like right away, you know, depending on the going down in the pipeline and stuff, to be able to reach out to them as
Right.
well. So I think just being a part of, like, you know, all the they're getting a lot of information when they're first coming on.
Right.
Letter of appointment, at least
Yeah.
just having all that information as part of that, they hopefully will read that. and
Sure.
That'll be the best.
Also,
place.
over the summer, like a lot of people are just not checking their email.
Yeah.
Yeah, no, I get that.
Yeah, I
And
get that.
also, I had something to say, but I forgot. Yeah.
The other thing that we might want to consider is in some way, shape, or form, giving you access that I think would be perfectly fine about notifying you when and if we have a new employee orientation or something along those lines, because that would be something that we might be able to work out. We have something like that with UFF. That way you have the access you would need to sort of tell your own story, and you know, we can facilitate you being present at the appropriate moment, but then we're not taking on the mantle of telling the story on your behalf. In other words, we say, hey, look, this is a process, or this is an onboarding thing that all new people do. If we can somehow facilitate you interacting with them at that moment, then it would sort of allay some of your fears that, hey, look, some of these people are new. We don't know where they're coming. The rosters, you know, when we give you the roster report, it doesn't line up with the time if you wanted to see them, which is really, like, I think that's a realistic concern.
Mm.
I think there may be some other ways we can attempt to sort of deal with that don't necessarily include us, you know,
Right.
mailing a letter on your behalf.
Right.
Because I think that's probably gonna be a tough one for us to sort of, but I think there's some.
Yeah,
other
the
things we might
letter,
be able to do.
yeah, I mean, we're
Okay,
amenable
well,
to that.
we're happy to hear what
Okay.
you,
All right.
Yeah.
We'll work on that one.
okay.
You got another one? Did we
We
have any
have-
other questions?
we have
Alex,
three
before
more.
we move on?
We could talk about it in talk.
Okay,
So we have 3 more proposals. We don't have a proposal for Article 25. As we said last time, probably that's gonna be one of the last ones that we TA, right?
okay,
But we did want to kind of respond to you to the question of how long the contract should
Sure.
be. So our position is we don't really have any interest in shortening the length of the contract. But we do understand your concerns of wanting to make it align with the fiscal year and
Right.
also wanting to stagger bargaining with the faculty
Right.
union. So if you want to align with the fiscal year, we can do June 2027, which would make it a 3.5-year contract, but then that would obviously align exactly with the UFF
I don't know if we're
bargaining.
legally allowed to do that, though. I thought there was a hard stop 3 years. I don't think we're allowed to
Okay.
legally do it.
Well, in that case, then I don't think we can agree to shortening. the-
That's fine.
Yeah.
I appreciate the fact that you considered it.
Mhm. Okay, so then the next proposal that we have, just give me a second to pull it up on my computer.
Would you be against us maybe starting a little bit earlier?
No, that is so, it was something we were
Okay.
open to, and I think we were discussing among ourselves, like 3 months is probably not enough.
It's not enough
Yeah,
time.
Yeah.
Especially because if nothing else, I think what we've all learned over the last 12 months is that every time that we have statutory or BOG implications for any of our work, it's probably gonna result in more sessions, longer sessions, maybe other mechanisms of the contract come into play.
Mhm.
So having additional time and an artificial hard stop date, it creates problems, especially because, and this is the other thing, and this is another, and again, I appreciate what you said. I'm not trying to convince you to go back the other direction, but because it starts when it starts, we already have employees that are in the cycle. So if it's something that impacts their employment in the middle of the year, it's gonna change their appointment in the middle of the, like, if it hasn't, you know what I mean? So it's just something else that I think more time would benefit everybody. That's-
Sure, yeah, no, we agree. So, for Article 3, it's honestly just a minor change, but, you know, essentially, we we think that it's important to be able to have a meeting with the university president
Mhm.
as opposed to a designee. And as much as we like talking to you, Patrick, I think there is a difference between talking to the president directly versus talking to a representative of the
Mhm.
president. And we would like to have a frank conversation with him and hear what his vision for the university is and for the future of our working conditions. And also, we think that he might benefit from hearing from us and about our concerns and thoughts about how the university runs its business. So we realize, of course, the president must have a busy schedule. So we do want to be mindful of that, but we do also want to have the consultation to occur, within a reasonable time window. So we felt like 90 days is a reasonable time window to, clear out an hour from the schedule. So yeah, those are the main changes that we proposed here.
All right, thank you for that.
So this would mean the only person you could consult with about any issues on the contract would be the president.
It means that if
Because
we
you've removed
request,
designation.
well, I mean, if we request a meeting with the president, then we should be able to meet with the president, right? Like, it's not that, okay, if we request a meeting with the president, then he sends.
But I mean, you could email 12 issues on Sunday night. And that would start 12 time clocks on 12 issues. And he would be bound, or she would be bound to meet with you on those 12 matters. Because there's no guardrail in terms of substance or timelines or how many or anything like that. I mean, I will just tell you the way it's written.
If you want to put in those guardrails, I
Yeah,
think we're happy to put that.
I don't see contractually agreeing to give you direct access to the president being likely. I don't think that's something that the university is going to be in a situation to agree to.
Are there guardrails that would make that more likely? Like what you're saying right now, like, okay, you can only discuss one
Yeah,
topic.
and
you can only-
anything that puts us in a situation where you can file grievances and unfair labor practices if the president doesn't agree to sit down with you directly, I think is unlikely.
And why is that, do you think?
Because how about, do you have any of your colleagues have that type of access to the president? Is there any other labor union that you're aware of at the university level that has that type of access? I've never heard of anybody demanding that type of access ever.
So you don't think that the workers who work for the university that the president runs have any interest in hearing from the president
That's
directly?
obviously not what I said. I didn't say that. What I said is I don't think that the mechanisms and structures of a university are such that there are direct dealings between the chief executive officer of any company and the labor force. That's why there are people in place to engage in bargaining, engage in consultation, engage in contract compliance, engage in grievance mechanisms.
Sure, I wouldn't think that there would be a direct policy change that would be the result of a meeting like that. It would be more just to have a frank discussion, especially, in the case of having a new president. Want to know what's your vision for the university? But okay, I mean, we kind of expected that.
My concern is more that by striking designee, that means you can't have any consultations with Patrick about things. Talking to the president about his vision is a big picture thing, but
Mhm.
coming to talk to Patrick about a one-off issue related to a GA who's having an issue with the leave, which you've utilized him for,
Right.
that means that can't happen anymore by striking the designee language. And obviously, you're not gonna wait 90 days to talk to the president about a individual GA who's having a leave issue. You know what I'm saying? That's kind of I shared Patrick's concerns, but I'm just concerned by striking designee. That's the president's the only one who can help you with that.
Right. Would there
No.
be, would it be possible just to have language and like some of the guardrails you said, just for being able to meet with the president, just for maybe very specific, like for certain things like the vision or just other things that the president would be more apt to talk about, just maybe some guardrails with that?
I think that we will listen to any proposal you have, but for the specific purposes of dealing with contract compliance, grievance matters, bargaining, unfair, any of those type of things, I don't see it being realistic. The president or the president's office is going to be dealing with those issues directly. I don't think it's likely that we would ever be able to agree to something like that.
Okay, thank you.
Okay, thank you. Then we also have a proposal for Article 4.
Okay,
we did say that these were gonna be, all have minor changes, however, this one is slightly more than minor, but because we said that
Right.
we would bring it last
That's
time,
fine.
we,
We spent quite a bit of time talking about Article 4 as well. Did somebody ask for a mic?
Yeah, so I was told that the battery was running out.
Oh,
Oh,
Battery, isn't it plugged in
Yeah.
to the wall?
I think the mic is.
Yeah,
Yeah, the owl
right?
is the mic, yeah. Yeah, we've been
it
good.
may be a different room.
Yeah.
I think we're good.
thank you.
Thank you. So yeah, for Article 4, we have basically changes to Articles 4.1, 4.2, and 4.7. So for 4.1, and this kind of goes with our proposal for Article 17 as well, a kind of providing a link to the new member sign-up form for GAU, and also a statement that GAs may contact GAU for any assistance. 4.2 is mainly just a statement. It's not necessarily committing the university to do anything, but it's more just acknowledging that year-long appointments provide job security for graduate assistants, and when practicable, university shall offer year-long appointments. It doesn't obligate the university to do so when it's not possible, but just acknowledges that this provides job security for graduate assistants and helps to attract better candidates.
And is there any, I'm sorry, I didn't- but on 14, is there any actual binding effect of 4.2 whatsoever?
No, it's kind of like how in the tuition program, like the first article is about just kind of a statement saying that, you know, the university acknowledges that this is good for the employees and it helps to attract the best employees in the future.
And 9 months, would you consider 9 months still year long, or you're saying
No.
that you mean 12?
12 months, yeah.
Hmm.
4.7A is a new provision that we've added there. And basically it says that anytime there has been a change in the appointment details, and that would be basically one or more of the options that have been outlined in the letter of appointment. Then for that would require an issuance of a new letter of appointment for the affected GAs. And such changes would have to be confirmed by a signature by the affected GA before filing. And then in the case when this is something has been changed due to a change in the CVA, for example, change in the minimum stipend, a revised letter of appointment will be sent to each affected GA, but it doesn't have to be signed in order for like in the same way that the original letter of appointment has to be signed. And for 4.7D, we've added also another new provision, basically saying that if someone has received and accepted an appointment, and that position is no longer available, the university will ensure that that person is placed at an appointment at equivalent compensation to the previous appointment, or at least provide that compensation in lieu of the position, while, you know, for the term that it was being offered.
I'm pretty sure that 4D2 is not legal under state law. We can revisit that, but I'm relatively certain that I think it's unlawful for us to pay someone if they don't actually work. Like, I don't, and there's also a limit of 6 weeks if we enter a settlement agreement. Like, I think there's a statute of prohibition of us paying someone who isn't actually employed.
If you
Yeah,
could
that's-
send us that or point us to
Yeah,
those statutes.
we can,
that
we'll
would
do
be-
that. I'm just
Alright.
letting you know that there's a legal hurdle for us on
Okay.
that one.
This for two, or this
For
for
D.
for D2?
D2.
Yeah, D2, I mean, I don't
Yeah,
think
right.
D1 is necessarily unlawful. We may
Right.
not like it, but it's not
Right.
like cast out of hand, like even if we like this, we couldn't do it.
Alright,
This just might be, again, my ignorance, but so how is this kind of different than 4.7C? So if the university, you know, so if an appointment is curtailed, diminished, or terminated because of lack of funds. Then we will make, it already says that we make every effort to reassign the affected employee. So then what, does it happen oftenly that, frequently, that an individual receives an appointment for a position that's offered and then it's no longer available?
I don't, if I can.
Yeah, please.
Cause I was kind of on this one. I don't know that we have like hard data that says that, and we would be absolutely interested in hearing more about that. Our interest is in all of the changes that have been like largely proposed coming down the pipeline for us, right? With like condensing all of the departments, right? That we foresee changes happening in people's lines of appointment if all of this stuff happens. And so we just want a protection that if we sign a contract that says I'm gonna be like working for 9 months, that we will have an appointment for 9 months. And I don't know necessarily that we're asking you to pay us when we're not working, but that you essentially will reassign us somewhere so that we can at least complete the contract that we've signed.
What if the reason is B4 though? What if the reason is because of B4?
I mean, it's still important to offer people pay. I think that's ultimately what we're trying to say, right? But there are a lot of proposals coming from the university that would increase this number and is gonna put exponentially more impact on GAs. We just want some protections, essentially, for what we've literally already signed. We're not asking necessarily for more.
And on the chat, from our president Ava, on the bargaining team, she has said that we have encountered this issue before. Our issue is very similar to it, so just to answer your question earlier, where you asked.
So this is, I just want to make sure we understand. So this is somebody who was like offered a letter and then they came to show up and they were like, it is basically, the appointment is no longer something that we can do and you're not gonna be hired now.
Now for the full, whatever, like the
Could be
9
someone else got that
appointment, for
appointment,
example.
like that is, like things get switched around in last
Right.
minute kind of thing.
Like, for example, like what Eva said, if someone has like a 9-month contract and then but they only worked at 3 months and then they're just told, oh, we only could have paid you for the 3 months and sorry, like, we don't have a position available for you anymore.
So
Just
it's-
protecting that.
So it's usually like a lack of funding issue. I don't know, Tom, if you have
That's,
any thoughts on that, when that might happen, but.
that's just kind of the example I gave, but like Hannah was saying, there's quite a number of other situations. Lack of funding is one of them, but there are other situations with like what Hannah said, with like departments like being shifted around and things like that are being closed, and which could be coming up, in the foreseeable future.
Okay.
Yeah.
Yeah, I wonder if it's something that could instead be addressed as one of the, adding a bullet to 1, 2, 3, 4, like if there's a
Right.
5, that could be added for whatever you're envisioning as opposed to,
Okay.
you know what I'm saying? And that's kind of, it's
Mhm.
kind
I
of
mean, that's
already.
fine if that's this problem, just moving it around, but like we said, we just really want just some protections to
I
make
just
sure.
think the language that says you will make all the efforts that you can is like great, but it's not necessarily a protection, right? It's not that it will happen, it's that it'll try.
It's not a easily testable provision. It's very nebulous.
Yes.
And so
Yeah.
we just kind of are looking for some guidelines. So if you have language that you think would be stronger and clearer, we're absolutely happy with that. It's just a matter of, there are a lot of proposed changes, a lot of people, I'm personally am nervous about this, right?
Mhm.
This is scary. We signed a contract to be here for 5 years and we can't just stop getting paid because something big is happening or something small is happening in the department and funds weren't properly managed. That's not necessarily our fault.
Yeah, but you, yeah,
and-
I understand that.
It conflicts with 4-4 though. This has come up
Yeah.
before in some of our cases. And that's one of the things that, we want to talk about and we had one on Article 4, but I think we're gonna probably not give it to you today because you brought us one on Article
Yeah.
4.
Okay.
But I think one of the things that we're gonna have to settle up is the fact that 4-4 exists, and we think that 4-4 is important. So I know that we had talked about many cases, Sikander, before, where Rachel and I talked at length about cases that conflicted, where you had a letter of offer,
Mhm.
which is a term that doesn't appear in the contract.
Right.
But we believe that, and I understand and appreciate the interest that GAU has with respect to what is the contractual obligation that a letter of offer represents
Mhm.
as, a contractual agreement or not. I appreciate and respect that. that interest and position that GAU has taken, how and in what ways does that interact with and intersect with the contract provision 4.4, which explicitly states that nothing that we give you will promise an interest beyond a period of 1 year. And I think that that is a space between those two concepts that we continually kind of come up against this
Mhm.
issue. So I think that no matter what we wind up agreeing to, I think it has to acknowledge or explicitly interact with respect to, have we made a multi-year commitment or have we not?
Right.
I think we just have, I think that's the big question that we have to
Mhm.
sort of wrestle
Well,
with.
you said multi-year, like, well, I think what we were trying to get at is mostly if you're already in like
A
a
12
9-month or a
yeah.
12-month contract, during that contract and something happens, just to
Okay,
continue the rest of that
I
contract,
got
not
it.
necessarily, yeah.
okay.
That's
So
what
it's a
this
little bit
specific
different.
language was aimed at,
Okay.
right?
Right,
So if
yeah.
in November you say, sorry, you're done, we don't have
Right.
any money. At least I need to get through spring. I'm on a
Right.
9-month contract. Like
Yes, yeah.
yeah, I need time to handle all of this stuff.
Right.
It can't just pop, you're done one day.
Yeah, so, or, if I come in for a 12-month appointment, I finish the fall semester, I go on winter break and I come back and they say, sorry, this position's no longer available, like, we just wanna just make sure that as the contract is just finished out, but beyond the contract, like multi-year or anything, that's not,
Okay.
So if that's the specific interest, then maybe what we could do is talk about, I'm not saying we would agree to this, but maybe adjusting the notice period that's listed already in what had been. With the new numbering, I don't know, but in the provision that starts with, in the case of 4.7. I don't remember, but in the case of 4.7, whatever, the university shall provide 3 weeks notice if practicable and make every effort to reassign the affected employee. Maybe that is a place where we could
modify that.
modify the interest to sort of get at what you're talking about. I think we would be
Yeah, that's
open
fine.
to. Cause I'm just not sure, to Olivia's point, how the new provision interacts with the provisions above. I think it creates.
I understand,
yes,
and
yeah.
actually, when I was reformatting the document, I kind of also saw that, there's a lot of similarity between 4.7 C and D. And I thought about kind of rolling it into one, but I just left it as is because that's
Yeah.
just, yeah.
That's fine.
We're just
yeah.
working out our thoughts.
Yeah, no, that's,
Yeah,
that's fine.
Yeah, so
That's
if
it,
we wanna
so-
change it to a different bullet point, that's fine, but we just, we just kind of, just would like this, that protection of just, having a little bit of security that, just one semester, you just come in and, jobs
Right.
out there.
Yeah.
Yeah,
that's all.
we get
Yeah,
that.
I mean,
get that.
we can't, we're not, as a state, we're not allowed to pay severance to anybody.
Mhm.
So that's why
Okay.
even like with our, at-will employees, we have, what is it, a 3-month notice period, and then we have all these
Okay.
different notice non-renewal
Right.
periods for people based
Right.
on how long you've been appointed, like that's
Right,
kind
right.
of,
Okay,
why we work a notice period in
Right,
because we're
right.
not permitted to. legally
and that's fine,
So that's kind of what
we're not,
Patrick's getting at is,
yeah.
right now, it's a 3-week notice period, maybe there's
Right.
some flexibility in that.
Yeah, well, and that's fine with the severance, really the main thing is just the actual security, like just honoring the full contract. And just being reassigned or anything, if anything happens with your current position, just sort of work out the rest of the contract.
Yeah, because really what 4.7 represents is a way in which the university has a mechanism by which we can legally violate the previous. I mean, that's really what 4.7 is
Yeah.
these are the conditions by which the university can break its previous contract with an individual.
Mhm.
I mean, in simple terms, that's what
Yeah.
4.7 is.
Absolutely.
It says, you
Yeah,
you
yeah.
previously had a contract, but if any of these conditions exist, we don't have to
See ya.
honor it.
Yeah.
Right,
Um,
yeah.
I mean,
Yeah.
it's not meant to be in it, but that's how an
Yeah.
employee may read it, is what I'm saying.
Yeah.
So, okay, well, that gives us some insight. I'm not gonna bring, we had actually worked on Article 4 proposal, but I think now we're not gonna give it to you because I think we want to recontextualize what we're gonna say based on what you've given us, so.
Yeah.
That's fair.
You
It'd
know,
be easier to have, that way we can add whatever.
Right,
we
we
accept
can-
from there.
we can make our modifications to your
Yeah.
version and show you kind of what we're interested in. Did you have other questions?
I had a question about 4.1. So when you say to add a direct link to the new member sign up form, is that different than the e-dues?
That is
That
the
is
same
easy.
thing.
That's
Yeah.
e-dues.
Oh, yeah,
Okay.
that's where they'll fill out all their.
And that form has the e-dues link on it or?
That is
something?
the-
That
That's
is,
just-
That
they're
is
the
just
same
the
thing.
link.
So there's a
to the form.
different, okay.
Yeah.
So that kind of with if we're looking back at Article
Right.
17, that's kind of.
Yeah, it was,
Yeah.
yeah, it was
Okay.
the same thing, yeah.
Got it.
They're all kind of linking together.
I just wanted to make sure that
Yeah.
EVs wasn't something separate than.
No, that's how that's the link we need to handle all that.
4.7A1 seems to be somewhat burdensome, that any change to the agreement requires 4,400 letters to be sent out. Is there any way that you would consider scaling back that
It's a
proposal?
It's that for any bargaining unit wide change, a notification needs to go to all students who are affected by it. It
Yeah.
doesn't need that all the students need to sign it, and specifically, we say that it does not need to be signed, right?
Yeah.
So like, if we ratify Article 10 midway through the semester and everyone's getting a change in their minimum stipend, we're just saying you should notify people, hey, your stipend's gonna go from 17,000 to 19,200. We just want them to be informed of changes in their appointment,
Right.
but we recognize it would be a large burden to have everyone re-sign it.
Right.
The only time a re-signature would be needed is if it was at the person level, which I think we're honestly doing anyway. It's just not in the contract.
Yeah,
Right.
I think to Robert's point, I think one of the things that I would be concerned about from a liability standpoint is if the union didn't appreciate or like the way that we communicated that change, I think it would be something that you may take issue with. So I think that maybe one of the things that we can consider is upon reaching some sort of formalized agreement, maybe we issue a joint communication that you guys sign off on. Like, I think we would probably be open to something like that. But if like we come to an agreement and then we put it in writing, if we were to even email it to everybody and you're like, well, that's not blah, 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 blah. Now we've actually compounded the problem by taking on the responsibility solely of having to communicate. I'm just worried about, to Robert's point, some of that too.
And what it says, it's saying it will just, the email would just be an updated letter of appointment, so it should be like something that's already, you already have issue sending out.
But it's a big lift.
That's
Yeah.
Yeah,
redrafting 4,700 letters of appointment,
Yeah.
as opposed to sending an email that's saying your new stipend is increased by this amount. Right,
Well,
because that's what you're asking for, is a letter of appointment, not
Right,
just a
right, and
notification of what the new pay.
And I think
rate
that's
is.
important because, the letter of appointment details all the specifications of the contract and what you're being paid, and if that's changing, people should, have that available for that. I mean, the first thing that kind of comes to mind where that may be important, kind of outside of that, is like, for a lot of like renting from places, you need to prove like minimum salary and stuff like that,
Mhm.
so having that updated, especially if that lets them rent somewhere where they previously couldn't, just to have that documentation to show that this is what they're making.
yeah,
That could also-
but a salary verification has a specific process by which if someone needs it, we can also produce it.
Yeah, HR probably already
If,
does.
so you're saying at request, we can get an updated letter of appointment for those changes?
But salary verification is not the same thing as a letter of appointment.
Okay.
Normally, that's a standardized letter that comes through. I think
Okay.
there's actually a self-service
It's
form
Yeah.
for it.
The work,
Yeah,
Okay.
work day.
work, no,
Work number.
the work number.
It's like a third party.
Yeah,
provider
yeah.
that
Oh,
you can
okay.
call and verify someone's dates of employment,
Alright.
title,
Oh, okay.
and-
I mean, it is definitely a need and it's something we have to take care of, but we do have kind of a way to get that
Okay,
done.
I
don't
didn't, I
want you
didn't,
to
I
think
didn't
people-
realize that, okay.
I don't want you to think people don't have access to that
Right.
right now, because that
Okay.
is something. we
Yeah.
have.
Alright.
Yeah.
Cause usually they just ask for most places though, I don't know if they even call and verify, they just ask for like usually pay stubs, but sometimes like for me, like when I first started, I didn't have any pay stubs, but
Right.
I used my letter of appointment to
Right.
show it and they accepted that,
Yeah.
But there's a difference between just modifications to someone's stipend. Because use that as an example, this is a change to the collective bargaining agreement, like any change, so.
That affects the
That-
details of the letter of appointment, which only includes that list of things
Mhm.
originally stated.
And
But
4.1.
if the
Yeah.
letter of appointment references the collective bargaining agreement, circularly, any change of any kind would then trigger this letter.
That's what I'm worried about.
If the letter of
So
appointment,
if we then provide notice that they work under collective bargaining and they're represented by GAU, and we make any change to the collective bargaining agreement, then by reference, any change we make is a change to the letter of appointment, because you said there's some
Doesn't the-
circular.
No,
doesn't the
no,
letter
sorry.
Just say you're covered by the collective bargaining agreement. It doesn't list all the articles
Yeah.
and details of
That's
it.
true. I guess what I'm saying is what represents a change to the collective,
Mhm.
at that point, what represents a
Okay.
change to the collective
So
bargaining? agreement?
maybe a better way to word it then is that if anything, if we make any changes to the CDA that would affect any language in their letter of appointment, that
exactly
should
it.
be sent out, which would really be.
basically,
the stipend.
those
These,
points here,
Yeah,
the things that are supposed to be
Including-
included in the letter of appointment.
Yeah.
If any of those things change as a result of the CBA,
Right.
which most of the time will probably just be the stipends.
Right.
That, or the
Or
fees.
do you-
That's kind of the way
Then-
we came at it.
Yeah.
It's really just a stipend. That's really the main thing that'll probably be changing.
Let us wrestle with that a little bit. We'll talk
Okay.
about it and we'll see if we can't give you guys a counter on that one.
Yeah.
There's some things that we have to sort of think through in terms of what are the swinging doors that would trigger,
Okay.
university-wide production of.
Yeah,
of
we
letters of
don't,
appointment.
yeah, I mean, if we change like some, this how something's worded in some random article, we don't
Right.
expect you to send out letter of
Right.
appointments to
Yeah.
everyone. for that.
But we also want to honor whatever we agree
Yeah.
to. Like, if we agree to something, we want to make sure that, we're like, well, at the table, we talked about that wasn't a big deal, and you guys are like, oh, no, that's a big deal. We need 4,400 more letters sent. Like,
Okay.
I just don't want to create a situation
Right,
where,
right.
we just didn't think
Yeah.
about all the reasons we would
Yeah.
have to do.
No,
it.
if you have better ideas
Yeah.
for how to make it very clear for that.
Yeah, we'll wrestle with
I mean,
that one and get you a counter.
Yeah, go ahead.
No, you can go.
Well, I just was kind of curious, like how are letters of appointment normally issued and what
It's-
is? the
yeah.
process?
So it's a very diffuse process
Yeah.
because it happens at every individual unit level, and in some cases, even within a unit, it may happen within disciplines within a unit.
Mhm.
So it is a very, very.
What do you consider to be a unit, like a college or?
So sometimes it's a department, sometimes it's a program, sometimes, it
So it's
is
very decentralized.
extremely
That's the
decentralized.
reason why it's challenging to
Yeah,
kind of, make sure that if this is in here, we have to agree to comply with it. But then that means we have to go out to like every single unit and department and make sure that they're doing it for every
Right.
single GA,
Right.
So,
Well, I
you know.
think, I understand that's a burden, but I think that is still important to make sure that departments are honoring the contract too and stuff like
Yeah.
that.
I think it's. a
the
very-
salary changes just get uploaded. I mean, they don't really have control over this. I mean, like.
Well,
they-
for the minimum,
Administering
yeah.
the stipends, like
Right.
that's done through UFHR, so that's
Okay.
like easy, like we don't have to really double check that.
I
right?
think
They're-
essentially
but-
what, at least what the intention was, is we're essentially looking for like an addendum, right? Like, if you wanna send like one single letter to everyone that says, hey, this change is being made and you're affected by it, I'm sure there must be a system where okay, these people are gonna be affected by a change in the minimum stipend. And you could send a single letter that says, I want to inform you, you're being changed by this effect. And if that would take some of the burden off of the kind of
Yeah.
nature of
Right.
reappointments, like
Yeah.
that's totally fine.
So if we were operating in a paradigm that all the appointment letters were issued centrally through UFHR and
Yeah.
sort of an ERP setup, which some universities have.
Mhm.
Yeah.
And it was just as simple as, checking a couple of contingency boxes and then just uploading and changing the template and
Yeah.
firing it back out through DocuSign. I think this would be a much easier conversation for us. But unfortunately, that's just not the level of communication and sophistication we currently operate within.
Alright.
So, it would take, the last time we had a conversation with them about appointment letters, there was 120 different HR liaisons on the call, I think. I mean, it was a lot, and not everybody was there. Like, I know, because I just don't want to overcommit to something we then can't make happen.
Yeah, sure.
But sending an email that just has an update might be easier as opposed to
Right.
regenerating letters of
Yeah,
appointment for every person. That's
Yeah.
kind of, I think, what the.
And then, yeah, and within
Okay.
that, it would need to say like, this change will be, like, shown in your next letter of appointment at the very least, right?
Right.
Like, this is an effective change.
Okay.
You're not being sent a new letter, but this will be in your. next
Because
letter.
panning back, right, the interest is that the employee has a firm and explicit understanding of exactly what the
Yes.
change is and how it will affect them. I mean, if
Yes.
we forget about the actual way
Yeah.
in which they find out, that's the overall overriding
Correct.
interest, is that no one is surprised by a change that may adversely affect them or, that's really what we're trying to drive at. So I
Right.
think if we operate from that perspective, I think there's maybe another way we can come to making that happen that you all find acceptable, that isn't necessarily reissuing all the letters of
Okay.
appointment.
Yeah.
So let us work on that, and we'll
Right.
see if we can't come back with something that you find acceptable.
I do.
And we don't think it's just for if it adversely affects them, even if
Yeah.
it affects them positively.
Sure,
because-
no, I
right,
get
Yeah,
yeah.
this, okay.
Yeah, but lack of knowledge. in
Yeah,
and of
exactly,
itself
right.
Adversely
Precisely.
affects them,
Yeah,
I think also, and this conversation has gone more to the larger bargaining unit, there's also the change to the individual level.
Yeah.
Right, so like if you're being moved from a course to a different course and your supervisor's changing, those are both details that are in your LOA. That needs to be resent to the individual student and signed by them. When that is not explicitly in the contract as it is right now.
and that should be a reasonable ask, at least at the
Yeah,
department.
I understand what you're
I
asking.
think that's all happening pretty much.
Yeah, I think it does happen, yeah.
We actually-
I had to do it
In
for
the
my,
contract.
And
yeah.
actually, I just met with Javier yesterday about one of these, and I think we got it buttoned up relatively quickly. So I mean, I think there's times at which
Mhm.
it's, you need to know who your boss is.
Right.
Like,
yeah,
that's not an unreasonable thing to know, is who's the person
Who's
that
the
reports to you, who does your evaluation,
Yeah.
who signs off on your leave, who ultimately makes the decision about whether or not you've done a good job. Like, I think you
Right.
get to explicitly know who that is.
Yes.
How we make that notification occur, how timely it is, what format does it take, all those types of things. I think we have some work on our side to say, all right, can we capture that and present it in such a way that you all find acceptable?
Mhm.
So that's what we'll work on.
Thank you.
We had a question in the chat from Ava, about, the salary verification request, and I'm not sure how that works, but she asked if the, email has information on how to do that for individuals, or if that's something.
I know it's on the UFHR website because I had to do it when I
Yeah.
moved here.
Mhm.
And it's a combination of an email and a phone call, I believe, and then you put it in and you put in who's verifying your income, and I believe it's just sent by a third-party service to say, you know, when you were hired, what your
Yeah.
position is, how long you've worked
Right.
there, what your salary is. I mean, it was, I think they did it in less than 2 hours for me when I requested it.
Okay.
I thought there was even like an automatic PDF generator.
Yeah,
that
it
you
generated
just
a PDF
downloaded,
email
right,
that I
right,
can then send on.
under my UF.
Oh, okay.
Yeah, if we still want an email, I mean, that'd be something that'd be nice to have for
Okay,
individuals.
we can
Yeah.
get you the information
Yeah.
on that. Yeah, that's,
Okay.
that's a good piece of, that's just a good piece of onboarding information in
Yeah,
general for
for
any of
sure.
our employees.
I didn't
Yeah,
know
and I
that,
never
yeah.
put that either, my own word,
Okay,
yeah.
well, we
I
can
did.
talk about
So that's obviously a large problem.
Well, had I
Okay.
not, like I said, had I not done it myself when I just moved here, I
Yeah.
wouldn't even know.
Oh,
So
yeah, okay, yeah, so. okay.
it's much quicker, by the way, than in organizations where you have to do like a verbal notification over the phone, which sometimes takes days and days and days.
Right.
Mhm.
Okay,
So,
that's great.
Thank you.
all right.
And we do have two proposals.
No, it's fine.
Okay.
It's fine. That's why we're here. Let's see them.
But these ones are relatively minor, so.
Okay.
Next up is copies of 4. Look at that.
Yes, I think so.
Sorry, I want to insert some of the language into the notes. Okay.
Okay, so this is our proposal for tuition program.
Okay.
Basically, the only change that we've said here is that the tuition waiver shall be for at least the minimum number of credit hours required to hold the GA appointment, or the minimum number of credit hours required by the department, whichever is more. So we have heard of cases where sometimes, in order for the departments want people to finish by a certain time, and therefore they require students to take more credit hours than what is required by their GA appointment.
Mhm.
And as a result, some of them have been on the hook for one to 2 credits, or 3 credits. And so we don't think that this happens like on a massive scale or anything like that. But we have heard of incidents like this, so that's just something we wanted to address. to the
Yeah,
con-
Tom, I mean, this is kind of in your court. I mean, what are your initial thoughts on this?
Yeah, I'd be curious how often that happens, if their unit requires more than the assistantship does. Cause that could be a pretty big cost, I don't.
Oh, I possibly, potentially, I have no frame of reference to how frequent of an occurrence this
And
is.
do we already have blank, I guess it would be here if we did, that says like up to 12 credits or something like.
Well, no, I think that's why the language specifically says, the graduate assistant appointment has a certain requirement.
Mhm.
It
Right,
doesn't mention what the program requirement is.
Right. I think program requirements can be up to 12,
Yeah,
and GA appointments tend to be 9, but there's a variability there.
yeah.
maybe it might be something we could say up to 12 or something like that.
Mhm.
Yeah, we would
Let me
probably
double
need to
check, let
pull-
me
Yeah.
look at that.
I can
But-
tell you it happens most commonly for master's students
Right.
who are often required to do 12 hours.
Yeah, I
So
would,
they would do 36 in a year, they would do 12, 12, or 12, 12 and 9.
12, 12 and 9.
no, yeah, so, and since, like, for example, I came on, not as a master's, right for my bachelor's, but I came on as direct on a PhD path, not on a master's path.
Right.
So I ended up so I've only been taking 9 credit hours for fall and spring and then 6 over the summer. But for masters, to get all those classes done typically in distant 2 years, typically that would usually require 12 a semester. But
Yeah.
yeah, so that's really a
That's-
big discrepancy there.
And some programs will say, here's what a degree plan looks like for 3
Right.
semesters, here's what it looks
Right.
like for 4 semesters. So I don't
Right.
know if someone opts for the 3 semester plan, would that count as being requiring 12, or is that, that's kind of optional because you're trying to get through in 3 semesters?
I'm not
instead
sure,
of 4?
I'm not sure, I don't think you can go above 12, right? Or
Yeah, so
do you know?
24, 30, so that would be, that's 33, right? Because 12, 12, and 9. So if there's programs that require 33 in a year,
Right,
then we would line up the ones that, not the students who take 33, but the programs that require 33.
Hmm.
well, there's
Well-
30, there's 36. I mean, that's what they all vary.
Right.
So,
Yeah,
so your point is that they may not require, like specifically say this is
They might even
required,
have a
but,
recommended
but they
degree
have
plan.
to, but it's kind of like an implicit requirement because you have to take that many to finish your degree, like, finish your degree in a
In
reasonable
3
time.
semesters versus 4. So you could,
Okay.
the department could come back and be like, well, you're not required to finish it in 3 semesters. If you do, here's our recommended degree plan.
Okay,
But there's also a 4 semester plan, and if you're on the expedited, that's where I just like,
well, even the 4 semester plan, if you're still taking 12 a semester, it's still where this issue may lie, where, yeah.
because I
you're
think
not getting the
that
full tuition.
the minimums are generally what's considered full-time, and that's usually
Right.
9 to 12.
Yeah.
So let me look at, yeah,
It intersects with 4.7A2, Tom, is what it
okay,
does.
okay,
Yeah,
okay, yeah,
we're
yeah.
back to
Yeah.
how do we determine in a litmus test? Is someone making satisfactory progress or are they not? I think it intersects with that definition, which is set by you guys and also at the program
The
level.
programs too,
Yeah,
And maybe,
because your example is there's programs where they're telling them to you gotta take 15 credits in the spring semester or something like that.
right,
Yeah,
Not
probably not
15,
15,
but
but it's
okay,
like 12 and their
right.
GA appointment is
Yeah,
9,
so-
like that kind of thing.
right, and so that can
And
happen.
again, it's not something we've heard of
Yeah.
happening very often,
Right.
like it's something like even this suggestion is something that came from like before I was even in the bargaining committee.
Yeah.
So it's not something that we hear about like all the time, like,
Right,
but it is something that has
Yeah.
happened.
Right,
And
we need
so,
to- we
yeah.
need-
And that's new, I mean, that would be definitely.
I mean, you can also look at maybe like just total like. Oh, no, never mind. Sorry, you already explained that, yeah.
well, that's something we'll have to look at. We gotta do
Yeah,
some digging.
yeah.
Sure.
Alright,
I think it's a lot of master students proportionally, but I don't think there are quantity, a lot of master
There's not,
students.
and that are fine, yeah, you're right.
Do we know how many, I mean, I have no idea. I know how many total GAs we have. Do we know how many of our GAs are master students? Do you have any concept of that? Off the top of your head?
No, not of the percentage, I know it is it's a
It's a
lower
very
number.
Yeah.
Sorry, I was just kind of also. Because there is also this issue of. If you consider contact hours. Like 12 full-time. At some point, you start getting this sliding scale at, well, at what point does the GA assignment get diminished to the point? What is it for 0.25? I wish Judy was here. Yeah, because there's kind of a scale, like if you're a 0.50 FTE. And we're waiving 12 credits, we're acknowledging that you're working more time and doing, more than 40 hours.
Well, we would be doing more than 40 hours anyways, right, on 9, if like,
Mhm.
For 9 red, for up to, yeah, that's the thing, but how far do we want to go with that? Like from the academic side, if we start saying, yeah, you got.
but
12
if it's
credits
already
every-
something that's happening, then
Right.
it's not like, that's not a
Well-
new thing required by this.
If it's happening up to 12 or 0.50, that's the thing, I don't know, I think there's a table, right, that says if you're 0.50, it would be 9, if you're down at 0.25, it could go up to 12. Let me look at that,
Okay.
Mhm.
that'd be great.
because I just don't want those to add up to
Yeah,
where the
Yeah.
expectation is greater than, you're basically 2 full-time positions, full-time student and full-time employee, let me look. Okay.
Yeah, I thought you were gonna say something.
No, it was just kind of a question of like, if that's the case, and this is already happening, right? There are definitely students who are on a 0.5 and taking 12 credit hours. There must be, even if it's just a small number.
Unless there's some policy that is against. but
Unless there's some, but it
I think
seems
we
like,
looked at the policies and it seemed like it was possible to do that.
Yeah, there's a
So-
table that
Yeah,
shows
yeah.
what this,
I was just thinking, would it then be like an issue that they are taking 12 hours to begin with? Not even just that we're covering 12 hours.
Right, Yeah, that's what I was saying. It's like, if it's already happening, that then it's not a question of like whether this would affect
It's
that. It's
just
more
taking
just
the
that they're,
burden of
the
proof.
waiver, yeah.
Mhm.
All right. We'll take a look at that one.
Okay.
You got another one?
Yes.
Good.
And that's the last one.
Okay. Well, I think maybe we have two then, because I think two of the ones are ones you've already brought, so we're probably not gonna give them to you, but I think we have, and they're pretty straightforward, so.
I'm just taking notes in a Word doc.
Oh,
Are you in? like,
Ava
the
was
shared
taking
doc?
notes, but Ava had to back out.
I was just gonna upload them when I was done, sorry.
Okay, so
Can I have a copy of the letter? Or is there an extra?
there
copy?
should be.
I guess it was just the one. They're the other there. I'm sorry. I just want this.
So Article 15, the only change here is basically the same language that we agreed to in the Article 10 tentative agreement. There's just a few minor changes. We removed the last line because we felt it was redundant with what is said in 15.1. Basically saying that, you know, if outside activities that the university determines that they interfere with the employee's obligation to the university, or there's a conflict of interest, then that activity is prohibited. So we felt like there's no point in repeating that. And we also just made more specific references to 15.1 and 15.2 rather than just saying Article 15 more generally. But apart from that, it's exactly the same. It's just moving that provision to the appropriate article.
Yeah, I think that, I think we would probably, just in a general sense, agree that this is probably a better place for it to live. I do think that we probably inside 15.2. I think we need to have some more robust language with respect to what is the responsibility of the university and what is the responsibility of the employee with respect to reporting in Ufolio. I mean, I did have some conversation with the conflict of interest office on that. So there's probably at least a sentence or two that we're probably gonna bring with respect to that, and it may cause us to maybe rethink that last sentence. Because, like I said, that is something that I've actually met with them about, and they have some ideas in terms of what that needs to do. But there's also, it's kind of like the letters of appointment. That system is pretty diffuse and split up, and it requires reviews and authorizations and all those types of things. So, you know, balancing the explosion of the sort of the paperwork with providing a reasonable notification that can be done by the employee without having to, you know, take an incredible amount of effort to do that is, I think, what we want to try to bring back to you. But in terms of generally moving this provision here, I don't see us having any real problem with that.
Great.
All right.
So we do only have 14 minutes left. I don't know if you wanted to still present your proposals or. leave
I
that
have
for
one,
next time.
I have one,
Okay,
if
yeah,
you want to
sure.
start, I mean, we
Sure.
might as well get
Do
them
you
across
want,
the
do you mind
table.
sending it to me electronically so I can put it up on?
Yeah, I mean, I'll send it to you afterwards, but I don't think it's gonna be anything that's
Okay.
particularly crazy.
Okay.
Because really, I just wanna see if we can't look at some of the CCL articles. I drew them up as MOUs just so you could look at them. I mean, the first one is just Article 1, and all I'm
Oh.
doing is presenting Article 1 as a CCL proposal, because we didn't have any changes in it.
What do you mean by CCL? I'm
Current
sorry.
contract language.
Okay,
So all I did was, because we have to go through the process of bargaining every article. I looked at our list of the ones that you thought you were gonna bring and the ones we thought we were gonna bring. And I just looked at the ones that we both said we don't think we have anything on there. So I'm just formally proposing that we go ahead and agree to the language in Article 1 as it's currently written. You don't sign it now, but just.
Yeah.
So the official proposal has been made for your consideration. And again, getting some of those articles that we aren't gonna spend any time on, if we
Sure.
can move them to the done column, that's all and we don't have that much time, so. There's not really a whole lot to necessarily talk about, unless it's one that you're like, look, this is something that we do wanna talk about. So it's just to get a sense of where you guys are on that one is all.
sure. I mean, from what I noted down last time was that 1, 2, 14, 18, and 23 are the ones that none of us have.
Well. Now that you brought it up. Here's number 2. Okay, so. You can go ahead and. again, it's in some respects, it's not a big deal, but just so that we actually have the paperwork that we went ahead and, you know, we officially proposed it, we talked about it as needed, and we both said that, look, we kind of like the way it is right now. So, I mean,
Sure.
like I said.
We'll just make sure that it's the same language and then, yeah.
Yeah, okay.
And that's good. And those are the two that we wanted to bring to the, we were, like I said, we did have a proposal on 4. I don't think it would make a whole lot of sense to give
Sure.
ours now.
No, that makes sense.
So. But, look, I appreciate it. You guys put in a lot of work, and I appreciate that you came with so many proposals, and I feel like we got through a lot of stuff today, so I really appreciate the time and the. Ask a question. It was a really productive session, so I appreciate it.
Thank you. Sure.
Appreciate it.
Do we wanna just say what we plan to bring for next time, or do you guys just wanna bring something since we brought a lot?
Yeah,
this
I
time?
mean, we will definitely have some stuff for you in terms of which ones we're gonna bring. I'm not 100% sure.
Okay.
But I think we're gonna definitely gonna talk about 17. We're definitely gonna talk about 4. I mean, for absolutely sure, those are 2 that we're gonna do.
So if it's okay with you, I think, we might hold off on proposals for
Okay.
next time.
That's
Yeah.
okay. Yeah, and after those 2, then we'll go, I mean, you gave us 5, so.
Exactly.
We'll prioritize those as well. Especially because at least with a couple of them, we think that we'll be able to give you a relatively quick answer.
Right.
Up or down on some of the language, and so that's good.
Okay.
All right, thank you all.
Thank you.
This was a good meeting, I appreciate it.
Thank you.
You guys have time to huddle up for a few minutes?
Oh, yeah.
Okay, guys, so, are we gonna send them the debrief link, or should we just do it in here?
Yeah.
You just want to verify that none of us are
We
there.
can, we can just use this and
Yeah,
then,
just verify that we're not in there.
yeah,
Yeah, no, it doesn't seem like, you guys are in
yeah,
there.
and then that's fine.
Okay, perfect.
Close the notes, or do you want me to take notes?
You can close the notes, if you could just upload or copy and paste into the notes that, Brandon.
I
and
thought
Eva-
you were, Hannah, I thought you were typing in here, but I think it was Eva and she was like doing like a transcript,